Okay, right. I think we'll make a start because we've got an awful lot to get through, haven't we, Gill, today?
Yes, we have.
Okay, so good afternoon to everyone, and thanks for joining us for today's webinar, which is for iHASCO clients exclusively. My name's Lucy and I'll be your host, and your expert speaker is Gill McAteer. Gill is Head of Employment Law Services here at Citation, and Citation is a sister company of iHASCO. One of the core services that Citation provides is a complete HR and employment law support package for business owners. Gill's worked for Citation for 18 years, so she really is an excellent source of knowledge, and this week is an ideal time for us to pick her brains after all of the announcements that came from the Prime Minister on Monday. About the roadmap out of lockdown and where we go from here. We're also joined by Colin Camber. Colin is a business development manager at Citation, and he can help you with any requirements you find that you might have when it comes to further support after the session. Feel free to ask questions throughout. There's a Q&A section at the bottom of the screen, so just type your questions into there, and then I'll hold them till the end of Gill's session, and then we'll try and answer as many of them as possible. I'll field them to Gill afterwards. We will share the slides after the session as well, so you don't need to furiously take too many notes. And if you do want to find out a little bit more about how the HR and Employment Law Service with Citation can help you afterwards, there'll be details at the end of the session, and we can put you in touch with Colin if you've got any concerns and his team. So without further ado, I'll hand over to you, Gill, because we have, as I say, got an awful lot to get through. Yeah, over to you.
Thanks, Lucy. Yes, we do have a lot to get through this afternoon. Good afternoon, everyone. What I'm hoping to cover is some of the implications arising from the Prime Minister's speech on Monday, showing us the roadmap out of lockdown, and then looking in particular in relation to some home working considerations, the intensely debated issues of COVID vaccinations and indeed COVID testing in the workplace. Looking forward to next week, thinking about perhaps what might happen as we await the Chancellor's budget speech and what the future of furlough might be, and then a very quick roundup of some key cases which have happened earlier this month and which we're expecting to hear about from the rest of this year. So first of all, the most significant step from an HR perspective to come from the Prime Minister's speech was the indication of where we're going to stand with home working. Many people have been home working really since the initial lockdown last March. We did have that period of respite in the summer when businesses were told to get COVID secure, and then people were returned, but then very quickly that was rode back on, and people were then told to homework again. So what the Prime Minister told us on Monday was that people should continue to work from home where they can. And that is something which is going to continue for the next few months. There will be a review. I've actually included an extract from the government's spring COVID-19 response document, which was an accompanying document to the roadmap out of lockdown. And it acknowledges here that the social distancing requirements are incredibly difficult for businesses, and they want to see a return to normal as quickly as possible. And therefore, one of the 4 reviews they announced was a review into to what extent those measures will have to stay in place, given that we've got a really ambitious rollout of the vaccination programme. And that report we've been promised will be published before the 4th step of the lockdown release, which is due to take place on the 21st of June. And following release of that report, they will then look to see what their guidance will be on home working. So as it stands at the moment, it looks as though up until very shortly before the 21st of June, we're still going to have the government guidance being you need to work from home if it's possible to work from home. One would hope that perhaps they will not leave it to that report to actually give us guidance on issues such as vaccination, because actually I think by the 21st of June, most employers will have had to have taken a stance one way or the other on that issue. But that's where certainly we're going to get a change of guidance on the home working question. So given that it looks like we're going to have home working with us for several months still, I thought it might be useful just to pick up on some points regarding home working. And one of the questions you're probably asking yourselves, if you have any element of home working going on in your business at the moment, which has been brought about by the pandemic, is whether you're going to have this as a permanent working relationship. Once we're looking forward to the autumn, hopefully we can get back to a near normal situation. If you're thinking, yes, this has actually worked out for us and we'd like to keep it as part of our working arrangements, the things I would be considering at this stage, if you haven't done so already, is first of all, what your employees' experience has been, because I don't think that, it's universal that home working has worked well for every employee. So it's very good to understand, are they happy with that? Because I've seen several cases recently where some clients have actually taken the decision that they no longer need to have business premises, and the employees are actually complaining about it, saying, well, actually, I want to return to a workplace. So how do your employees feel about the experience? Do they want to continue working from home? Are you going to have this as a full-time or a part-time arrangement? A lot of employers going for some sort of hybrid arrangement, because whilst they can see all the benefits from home working, they do also see the benefits of having people get together in a workspace, particularly with regard to engagement, having various departments aligned in what they're working towards. And then if you are thinking of it's going to be permanent, now probably is the time to start looking at whether or not you might need to make changes to your contract, the contracts of employment. Things to consider there will be, are you going to change the place of work to home, or is it going to be a hybrid position? It's very important to spell out the flexibility you're going to need there. Are you going to make it conditional, for example, on their performance being satisfactory? Those are things to think about. Hours of work, are you going to expect them to be working the core hours that you would have expected them to do in a workplace, or is there going to be more flexibility there? I think it's very important that you do spell out if there are core hours where they absolutely have to be available. I think for a lot of people, a lot of employees, the experience of home working in a pandemic is not a normal home working experience. And, certainly, with the needs of like homeschooling and things like that, there's been a greater degree of flexibility than one would normally expect in a home working arrangement. So it's really important to spell it out in the future, if this is going to be a permanent setup, what your expectations are, and indeed what their contractual obligations are. Confidentiality, I think this is very important, because obviously as an employer, you've got much less control over this if your employees are working from home. So making sure that there are very, very clear obligations to keep company information confidential when working from home, very important to have in the contract. And you could even consider something like a right to enter, which has got lots of issues in terms of enforceability. This would be a license to enter for the purposes of maintaining equipment, etc., or indeed getting equipment at the end of the working relationship on reasonable notice. But it can sometimes be helpful to have it in just to manage expectations. But you would want to take advice before enforcing that. Also, if you are going to look at a permanent home working arrangement and you haven't done so already, and I guess we're now in quite long-term home working arrangements for many people, reviewing your management processes going forward, how you assess productivity, how you ensure that your employees are being trained. That's probably something which has not really been at the forefront of most people's minds when it's just been a question of let's keep going, let's keep operational. But training will be important for the future. How are you going to manage this when your employees are working from home. And indeed, that might be one of the reasons, for example, where you do want to build that flexibility into the contract, that you can require them to come into work when needed. And your communication strategy as well. I'm sure you've all been considering, if you do have home workers, the different ways you can communicate with them, regular contact, making sure they stay engaged. It's absolutely essential, I think, if you haven't done so already, to start formalizing this into a homeworking policy, because it really sets out what the expectations are and the obligations are on both parties. And there's no doubt about it. Even things like, for example, sickness absence reporting. If you're moving to a homeworking arrangement, you need to be quite clear about what people are expected to do, and expenses. If people are going to be staying at home, they're expected to come into the office, are you going to be paying travel expenses for that? And if not, make it clear you're not. So it just cuts out the room for debate and indeed conflict later down the line. A very important aspect is going to be obviously the equipment, and in particular the acceptable use of that equipment. Obviously you might have quite expensive equipment in the employee's home where all members of their household have theoretically got access to it. So these can be included in a general policy, but I think it's sometimes a good idea to actually spell those obligations out in a separate document. And so just very quickly, the sorts of things you'll be looking at there are, who owns it, who's responsible for servicing it, the insurance position, what happens if it's damaged, are they going to be responsible for the costs, getting an agreement to deduct the costs of repair from their wages, what it can be used for, what it can't be used for. Obviously, the security of data is a very, very big issue now with so many people working from home. So making sure that you have got provisions in there which preserves the hardware and software security, covering things such as email use and password security, and actually giving employees training on this. I think this is something that we increasingly see now, so that employees don't inadvertently click on emails and then potentially give third parties access to your systems. That's very important to consider. What happens if there is a security breach? The last thing you want is for someone, if they have clicked on something and then realized actually that wasn't what it was supposed to be, they're not reporting that to you. So making it a positive obligation that they have got to report security breaches is very important. And indeed, with all of these provisions, making it very clear what the consequences will be for not complying with it, because this is definitely something you might need to take disciplinary action for. If you don't think this is going to be a permanent part of your work arrangements, if you're thinking, well, I'm actually on countdown now to June or July when we can get people back into the office, it's very important at this stage to be thinking about, well, why is that the case? Because, of course, there's a good chance that your employees might be quite happy working from home. And this potentially is a huge area for conflict in the future. Already we have seen this as being one of the greatest areas where we've seen claims come in as a result of COVID, of people thinking that they haven't been allowed to work from home when they want to work from home. That's a very, very big area of litigation at the minute. And bear in mind as well, of course, that there's one issue about whether or not people can work from home in the COVID context, but employees have always had, over recent years, the right to request flexible working, which would include a home working arrangement. That's available at the minute to all employees with over 26 weeks service, although a campaign has been launched recently. Yet again, this is something that they've tried before, to campaign to make this a day one right of employment, but it's the right to request. the flexible working arrangement. It's not a right to be given exactly what you want. And there are 8 statutory reasons why you can say it isn't appropriate for the business. But this is, again, an area in employment law, I think we're going to see a completely different perspective on these applications. I mean, I've, advised on, probably hundreds of these applications in my career. And it used to be quite simple because employers could always think of reasons why it wouldn't work and to rebut it, and you'd feel quite comfortable about saying that. But actually the reality is, because of circumstances, people have been doing it. So if you don't think it has worked, you're going to need a bit more to actually establish a case for saying, no, we don't want to do this permanently. And I think it's worthwhile flagging the mistakes that I see that businesses easily falling into when they look at this. So I think, first of all, it's very, very tempting to focus on the individual and rather than the role. I hear all the time, look, it's difficult enough to get a decent day's work out of this person when they were in the office. So, I just don't trust them to work from home. A tribunal would look at it. Can this role be carried out from home? So that's something to bear in mind. You really almost need to focus on whether the role can be done. And then if there are issues with that individual, tackling it that way. Not having the robust evidence as to why it's not working, this is really the key. It's just saying it's not working, but not having the evidence to point to it. That's a common flaw in defending these types of claims. And making decisions based on what other employees would say about it rather than on the individual's case. I've seen cases, for example, where the employee had quite a good reason why they should be working from home during the pandemic, but the employer had not wanted to do it, either because they thought, well, if I give it to one person, then I'm going to have to give it to everybody, or thinking, well, if I give it to one person, they're not going to pull their weight and I'm going to have constant complaining from other employees in the team. Whilst that's completely understandable from a human perspective, actually your actions will be judged on, did that employee's case warrant working from home? So that's something to look out for as well. And therefore, if you are counting the days until the government guidance changes and you can get people back into work, that my advice would be, start focusing now on collating that evidence about why it's not working, and actually speaking to your employees and letting them know if there's areas that it's not working, so that it doesn't come as a surprise at the end of the day when you're saying, no, I don't think this is going to be a suitable permanent arrangement. In either event, I think it's important to be looking at health and safety issues now. Obviously, in the immediate aftermath of lockdown, it was quite helpful. HSE came out and said you don't need to consider health and safety really if it's a temporary arrangement, but we've gone well beyond temporary now. So at the very least, you should be making sure that their employees have carried out a display screen equipment assessment, and the HSE have got guidance on how they can actually do that themselves. It's a checklist which you then have to review. So that's really an essential point if you haven't done that already. And focusing on their mental well-being. We're thinking mental health issues in the workplace it's going to be a massive issue, regardless of whether or not people have been working from home or not. But I think home workers are particularly vulnerable because you don't have as much visibility on how they're feeling. So really, when it comes to the economy bouncing back, you want everyone to be sort of fighting fit and fully engaged. So really do consider what your strategies are to make sure, both in terms of communication, training your managers, raising awareness in the business of talking about these issues, about how mental well-being is being addressed within your workplace. So then turning to COVID testing, I'm going to say quite a bit about COVID testing and COVID vaccines, but you'll find that there are common threads throughout this, which I might as well just highlight at the very beginning. I think, first of all, when you approach these issues, it's really important to consider at the outset, what are you trying to achieve by introducing these policies in your business, and bearing in mind the impact this is going to have on the individual, because under normal circumstances, you wouldn't even be thinking of actually carrying out tests on employees, medical tests on employees, or, you know, actually requiring vaccination from them. So that has quite a heavy impact on the individual. It's certainly an infringement of what their privacy rights would be, although those privacy rights are not absolute. So be mindful of that. It's always going to be a balancing exercise about what you want to do, why you need to do it, and the rights of the individual, but certainly being very clear about that, being clear about what you're trying to achieve, and communicating it clearly with employees, trying to get them on board with it as much as possible and engaged with it, is going to be really, really important in establishing that you're doing things in a fair way. So with COVID testing, of course, the key issue why this is so important is that all the evidence seems to suggest that around a third of COVID cases are asymptomatic. So if your workplace is open, you can have people coming into work who may be carrying the infection. Obviously, you'll have your COVID secure arrangements in place, but it does still impose a significant risk. And increasingly, the HSE are finding that workplaces are a centre of outbreaks. In fact, there have been times where certainly there have been more infections that have come from workplaces than have come from, for example, hospitals or care homes or prisons. So the HSE are definitely taking a very close look at this. And the government have been, over the last couple of months, really promoting asymptomatic testing throughout the country, which has been led by local authorities. And they have got a workplace testing programme. Now, this previously was available only to businesses who had 250 or more employees, but at the beginning of this month, they extended this to businesses with 50 or more employees. So this is whereby if your business is registered in England, has 50 or more employees, and has employees who can't work from home, and they don't say that it has to be a certain minimum percentage of people who can't work from home, the government will provide you with free testing of your employees. This had been announced that it would be apply until the end of March. Actually, in the Prime Minister's speech on Monday, he said they've extended that now until the end of June. So if your business meets that criteria, you have the ability to access free COVID testing. Now, there's lots of practical considerations there. Is this going to happen on site? Because actually the test materials would be considered to be clinical waste, etc. But Test and Trace offer a lot of guidance on exactly how you can set up a testing area, and indeed, if necessary, you can actually use the local authorities' asymptomatic testing facilities. So this is something that Test and Trace would actually guide you through. If you're interested, and if you haven't done it already, there is an online portal. You just have to enter your company name, your contact details, and your company registration number, and then they will come back and guide you through the process. So if it's something that you're interested in, obviously there's the government maintain the list of private providers as well if you don't meet this criteria. But this is free testing you can access if you're a business of a certain size. But the million-dollar question in all of these scenarios is, can I force my employees to do it? This is something, as with vaccines, it shifts on a weekly basis, the perception. When I was first looking about whether you could make COVID testing compulsory back last autumn, this seemed like quite a significant step. It is now becoming more commonplace. We have seen sectors such as education and of course the health service, where they've been regularly testing since last summer. So it is already, over a very short space of time, becoming more of an accepted norm. But even in health and social care, where there is a very, very strong expectation that it will be done, it's not actually a legal requirement that it's got to be done. But definitely, I think the tide is turning in that way. The government have been placing more and more emphasis on asymptomatic testing, workplace testing, being, really critical in our route out of lockdown. So I think there is a lot of support there if businesses wanted to take that approach. But as I say, you need to consider why it's necessary and think about the impact on the individuals. So the reasonableness of this approach will depend on factors such as the level of risk in your workplace, the adequacy of your existing COVID secure measures. So for example, if people are working more or less in, alone in an area of the workplace, that's going to seem less reasonable than if you're working alongside people in an area where social distancing is quite difficult to maintain. Frequency of contact with others, the extent to which you could achieve the same aims from additional measures, and the extent to which this is really going to improve the risk profile of your workplace. Now, the government has actually given quite comprehensive guidance on this, which is helpful. So what they've said, what you need to be considering about if you want to introduce this policy is who testing is going to be cover, what the focus of the programme is going to be, staff with symptoms or without symptoms. Now this, although this guidance was updated in December, it had been produced earlier in the autumn, and what I'd say is that the focus of this programme should never be staff with symptoms. They're completely outside asymptomatic workplace testing. Employees with symptoms should simply not be in your workplace. So how often do you plan on doing it? What facilities are you going to use? Which test you're going to use? Are you going to do it privately? Are you going to use the government's provided tests? What the arrangements will be for those individuals who do not wish to be tested, what the employer will use test results for, whether this is quite a sweeping comment, but one that you see increasingly in government guidance, that they leave it to the employer to decide whether your proposals are compatible with health and safety, equalities and data protection and employment law obligations. So it's quite a sweeping comment there. And also there is an obligation to report your results to Public Health England, and who is going to be responsible for that. Again, that's something that Test and Trace would take you through in terms of your obligations. In terms of communicating the guidance to, or the communication, your policy to employees, strong advice from the government is speak to them before you implement any policy. And I would say absolutely, as with most things, your chances of getting employee engagement are going to be much higher if you start the dialogue early, explain why you're thinking of doing this, why you feel you need to do this, and get them on board at an early stage rather than just rolling out a policy. Transparency is absolutely key, and employers should communicate clear information on, why you're doing it, whether it's voluntary or mandatory. Again, just to be absolutely clear on that point, you could make this a mandatory policy if the circumstances, were such that it could be justified, which is difficult to deal with, in this short session. But you look at, for example, the care sector. Most of our clients, we act for many care clients, they are, operating very smoothly without issues of people not wanting to be tested. And I think the whole consensus has been that a voluntary approach is better, but a voluntary with a very clear expectation. But if you did have a situation where people were refusing, I think in a sector such as that, it could be justified theoretically to actually introduce a policy if you follow the correct measures. But it will all depend on the circumstances of your business. Of course, you can't force anyone to have the test. The way you do it is to actually say, right, this is the policy. It's necessary to have it. It is compulsory. And meeting all the other criteria for data protection and communicating it in a reasonable way. You would still have to very carefully consider why someone is refusing if you wanted to take action on it. So it wouldn't be, right, you're refusing to do it, that's it, disciplinary action and potentially dismissal. You would have to look at it very, very carefully as to why they were refusing to do that. what are the next steps for staff when they receive the result, where staff can get advice on their rights throughout the process. I'm quoting there from the government guidance. I don't know anyone who would want to be putting that in their policy, frankly, because actually that might be referring them to ECAS, etc. And so most people perhaps would not put that in, but would be putting, if you're concerned about the policy, this is who you go to speak to within the organisation. Equally, with regard to collection of data, if they've got any concerns about that. And you know, obviously informing them what they need to do if they get a positive result. I won't go into too much detail. As Lucy said, you're going to get these slides afterwards, but it's also a very, very important element of this, the data protection considerations, because you are going to be collecting here special category data, which is particularly protected under data protection legislation. So the first thing you would have to do there is carry out an impact assessment. You actually find that there is a lot of parallels between what you need to do to be following a correct process from data protection and what you need to do from an employment law perspective. So the data protection impact assessment, I think, is quite useful in showing why it is actually necessary from an employment law perspective as well, because you have to talk about what you're proposing to do, what the data protection risks are, but why that action is necessary and proportionate, and what you are going to do to mitigate any risks. And as I say, central to this is, from a data protection as well as an employment law perspective, is why is it necessary, and showing that you have considered the impact on the individuals, but you still think it's necessary for your business. As in lots of things in employment law, it's very often not necessarily the decision you end up with that's going to be, you know, ultra scrutinized, as long as it's within a band of reasonable responses. It's more about the process in which you've done it. So if you can show that you've taken all these factors into account, but you do reasonably think that this is what's right for the business, you will have gone a long way in making sure that you're operating safely within your employment law obligations, and keep it reviewed regularly. That it is a very quickly changing situation. The guidance also says what you should tell your employees, which, as I say, you'll have all details in the slides which will be sent out. But again, it's all about making sure that that is what happens with their data is in line with their realistic expectations. So basically what you have told them. So a well-considered policy is essential from both an employment law and a data protection perspective. Some additional things to consider: privacy notices. You'll hopefully all have privacy notices telling your employees how you'll deal with their data. The Information Commissioner's Office recommends that rather than simply updating your privacy notice, it is actually better to do a supplemental notice. Although I think if you've done a revised one, that's probably fine, but their preferred way of doing it is to actually do a supplemental privacy notice on how COVID-related data is going to be dealt with. Be aware that if you are running these workplace testing programs, complacency can creep in. There's been a lot of publicity about the fact that lateral flow tests are not as reliable as PCR tests. They're good at identifying those people who are the most infectious, but certainly you do need to have a higher viral load for them to register positive. So it's really important that you don't let there to be any slip in your COVID secure work arrangements. And it's not intended for people who've got COVID symptoms. As I say, if people have got COVID symptoms, they don't come into work and take a test, they stay at home and they get their PCR test. And if you have a positive test, and I'm sure this will be addressed through test and trace as well, but if you have a positive lateral flow test, you need to start self-isolating, but you need to get a PCR test as well. The vaccine, again, this is hugely topical, and I literally every day at the moment, I am sort of scanning every minister's comment on it to see if we can pick together where the judicial or the politicians' thought process is going with this one. So, can you force someone to be vaccinated? The simple answer is, of course, no, you can't. Not even the government can force anyone to be vaccinated under current legislation. But what you can do, theoretically, is impose a requirement on employees that they be vaccinated. And then the big question is this going to be seen to be reasonable? And really, where the government's going to stand on this is where we're all looking at the minute, because actually there is no guidance, there's no precedent we can look at. We have an absolutely blank employment law rule book here when it comes to this. So we're really looking to the government to say if they can give employers a stance of what's likely to be reasonable. The government have repeatedly said that the vaccine programme is going to be voluntary. But increasingly, and we see, and I'm talking really over the last, week and a half, we've started to hear comments about it. Well, we're not going to make it compulsory, but it's up to businesses and what they want to do. And in their spring response to COVID, in that document I was referring to earlier, they do say that the high vaccine take-up is crucial and everyone who's eligible should make all efforts to get vaccinated. So the policy very much seems to be, well, we'll stand on the sidelines and we'll let businesses make their own decisions. But they have accepted that that may mean that it will be for individuals who do not like those conditions to go and raise those issues with tribunals, and it will have to be tested by tribunals. I would sincerely hope that that is not going to be the stance that they take over the coming months, because quite frankly, by the time those cases ever come before a tribunal, and of course, these decisions are not likely to stay at tribunal level. They're likely to be appealed. It could be years before this question is settled about what a reasonable stance is. And every employer wants to, guidance on what they do now. So I'm hoping that the calls for clearer guidance from the government will be heard and be acted upon. Very interesting. And again, when we look at care, this again is an area where there's more movement, because obviously the risk in care is much higher. It's the top priority group in terms of the vaccination programme, and unlike any other sector at the moment, really, it is the area where vaccines are available. So they're really dealing with these issues at the moment. It was interesting that in the press conference after the Prime Minister's speech about lockdown, at the very final question, the Chief Medical Officer was asked, did he see whether it could be a condition, specifically in health and social care, that people have the vaccine and of condition of their employment. And he didn't sit on the fence with that at all. He said that from his background as a doctor, he considered it was the professional obligation to take the vaccine to keep patients safe. And he considered it was the professional obligation of other people working in health and social care to do the same. But in terms of actually requiring it, he felt it was a political decision. At which point Boris Johnson said, well, I'm not going to duck that, since Chris has given the implication it's a political decision, but then sort of ducked it by saying, yes, I know some care providers are actually, requiring this now. And not really saying whether he felt that was a good idea or a bad idea. But it was interesting that the following morning, yesterday morning, the health secretary was quoting that when asked exactly the same question. He was quoting Chris Whitty's response and saying, well, the Chief Medical Officer has said that he considers it to be a professional duty. So there seems to be some tacit support there when it comes to the care sector. But what are the risks of a compulsory approach? Now, there is a distinction between employees and recruitment candidates. And I think I should point out as well that although there has been a lot of publicity about some care businesses, such as Barchester Care, very, very well publicised case where they have said that they are going to require this. They have taken that approach with their new employees. They're building it into their recruitment program, but they're not requiring it for existing employees. The approach for existing employees is very much about encouragement. And that's because the risks are different with those two groups. So for your existing employees, particularly those who have got 2 years service, they can bring claims for unfair dismissal if you were dismissing them and re-engaging them on new terms, requiring them to be vaccinated, or if you unilaterally just change their terms and conditions and say, right, from now on you have to do this, they can bring constructive dismissal claims. So the stakes are higher with existing employees. Whereas with recruitment, the only claims really that they can bring is discrimination claims. And of course, your existing employees can bring discrimination claims, and they are day one claims as well. So is it going to be a reasonable management instruction to suddenly ask your employer or tell your employees that they're required to do this? No, I don't think so, in the sense that it's not going to be something which is generally arising from the sorts of instructions you would have been used to been giving them. There's a stronger argument in care, but I think even in care, it's still not really reasonable to suddenly come in one day and say, well, yes, of course, this is a perfectly reasonable expectation. It would have been in your expectation that you would have been asked to do something like this. It's going to have to be a new policy you're introducing. And most businesses will not have anything in their contracts which would cover suddenly introducing something like this just as a contractual right you've got at the minute. So this is probably going to be either, the introduction of a policy, which really you should be consulting with your employees on. And, some people might take the view of saying, well, I'm actually dismissing you and actually re-engaging you and having this as a contractual term. And be aware with the numbers there, because if you're talking about 20 or more employees, you're actually engaging collective consultation provisions as well. The potential discrimination issues are age. I mean, not in the care sector where the vaccine is available to everyone, but if you are in a sector outside of that, so far we are working through it on an age basis, age and particular vulnerability basis. So younger employees, if you were to have a policy saying, I'm not going to recruit anyone who doesn't have the vaccine, you're immediately excluding younger employees. Pregnancy and sex discrimination could be an issue here. Obviously, if you were not to have a policy which said, an absolute blanket policy, I am not going to employ anyone who is not prepared to have the vaccine, or requiring everyone to have the vaccine, although it's assumed that it probably will be safe for pregnant women, as it hasn't been tested in pregnant women. At the moment, the advice still is not to have it unless you discuss it with your clinician. So therefore, there could be issues there. Disability, if people have medical conditions, which means that they shouldn't take it, again, that's a potential issue if your policy doesn't allow for that flexibility. And religion or belief. Now, I think, again, this is possibly an area where there are a lot of misconceptions about vaccines. It would be against my religion to take it, whereas I think virtually all the leading faith leaders have come out and said that there's no bar for religious reasons in vaccination. So that's definitely something to bear in mind. When you're deciding on your policy, again, as I say, think about the impact in the individual. The safest approach at the minute is, I think, unless you're in care, where I think probably, even then, I think, the real focus is going to be, let's get the hesitant ones, educate, encourage, inform those who are hesitant, and then let's leave it until you've got a stubborn group who just refuse to listen. and then make a decision about what you're going to do with those people. And we possibly haven't got to the end of that encouragement and education piece yet. So I would say at the moment, active encouragement, and watch for the clinical data and government guidance, because at the moment, the key thing we don't have is that clear evidence of what the impact there will be on the transmission to others. And that will be, I think, a bit of a game changer when it comes to the introduction of these policies and certainly government guidance. Because at the minute, what we do know is that the fantastic impact it has on the risks of the individual becoming severely ill. So really, vaccination still is primarily about keeping the employee safe. But once it becomes absolutely clear, and if you're vaccinated, this is the impact it has on transmission, and as I said, we're getting closer to having the full picture of that now, then it much becomes about, this is actually something I need you to keep other people safe, and that's an easier case to justify. So again, the data protection is going to be absolutely key. Communication, absolutely key. Training managers, absolutely key, because there's going to be a lot of decision making here, which you need to be consistent about. What is a fair reason to say no? What does your policy allow? A good policy will be a flexible policy, but with flexibility, there's a huge risk of inconsistency. So training managers, and I would say actually having one person in the organization with an overview who's responsible for these decisions is really helpful. And also bear in mind, and this is a side issue, you're going to be gathering lots of information at interview stage if you do have it in a recruitment policy, which you wouldn't normally have. So for example, if someone is saying, I haven't had the vaccine because I'm actually 2 months pregnant, well, that's not information that normally you would want to know in an interview. So you need to make sure that all your recruitment decisions are absolutely objectively robust and can be defended, because you don't want someone coming around saying, well, you were fine with me not having a vaccine because I was pregnant, but you didn't give me the job and that was because I was pregnant. So be careful on that as well. End of furlough very quickly. Will it end next week? Well, good news. The Prime Minister was saying that they won't pull the rug out from businesses and they'll do everything they can to protect jobs, given that the lockdown roadmap goes well beyond the current end of furlough. I would hope that we will see an extension of furlough and not the return, well, I want to say it didn't really get off the ground, but the return of the job support scheme, the open and close scheme. I'd think that perhaps if for the sake of 4 months, everyone knows how to use the furlough scheme, the Chancellor may be tempted to extend that rather than introduce a new scheme at this stage. And potentially we might see something about the job retention bonus coming back, but I don't think that if it does come back, it will be in the same format that we have before. Very, very quickly, in terms of a case roundup, you will all have seen probably because it does make the front page of most of the papers, the Uber case. It's an employment status case where the Supreme Court has held that Uber drivers, although they're set up to be self-employed and they've got contracts saying that they're self-employed, they're actually workers. Workers being a very confusing middle category. You've got self-employed people who are in business on their own account on one end, employees at the other end. In this middle category are workers who have got no continuing obligations to you, but when they're working for you, they're entitled to, the vast majority of employment rights, apart from unfair dismissal rights and redundancy rights, etc. So that's what they were held to be. Key points from that judgment are: don't think that what you've put in your contract is going to determine what the employment status is. I mean, we could easily do a whole hour on employment status because it's such a complex area, and we have got a very flexible workforce now, many of whom are working under descriptions which actually don't match their correct legal status. But key point: doesn't matter what it says in the contract if the facts of the case point to a different employment status. Then we had earlier this month, the Employment Appeal Tribunal gave a very stark warning to employers about when they could be responsible for the harassment carried out by their employees. So in Gellin and Ale, this was a case, Mr. Gellin was dismissed he had just under a year's service and was dismissed for poor performance. You know, on the face of it, a short service dismissal, no risk. He then brought a claim saying, well, actually, I have been racially harassed at work, and I'm bringing a discrimination claim. Now, the employers, didn't know about this, certainly wouldn't have approved of it, and tried to rely upon the statutory defence. The statutory defence is that they had taken all reasonable steps to stop harassment happening in their workplace. And unfortunately, it was held that that was not good enough, what they'd done, because the training they'd given was 2 years old, and they didn't think it had been particularly effective. And what they were saying is that really they couldn't show they'd taken all reasonable steps because that training was stale. And they actually went on to say that, training is unlikely to have long-lasting consequences if it's not more fully focused and higher quality. So that's going to be absolutely key to ensuring that you can use that defence. And that defence is so important because actually we don't have eyes and ears in everything that happens within our business. And, the old thing that a manager might be overlooking. So if you want to sort of rest easy that you've got that defence, that's really going to be key. And finally, cases to watch out for this year. We've got a number of holiday cases coming before the Supreme Court, looking at the issues of whether or not you can introduce, or whether you've got to include voluntary overtime in holiday pay, whether how far you can go back to recover holiday pay claims. This is going to be incredibly interesting for employment lawyers, but also very significant for businesses, because this is the first time the Supreme Court has had its chance to put its stamp on holiday cases since we've left Europe. And most of the developments in holiday pay over the last few years have all come from European cases. So that is definitely something to look out for, and it will have repercussions for all businesses. Brazil and Harper Trust, I know we've got some education businesses on the session this afternoon. The issue of how you calculate holidays for term time workers, and whether you can prorate it, which has gone against employers in the last few times. It's up in the Supreme Court in November. And I know, again, we've got some care businesses there. Eagerly awaited Supreme judgment on the Royal Mencap case is, are people who are doing sleep-ins where they're available for work, not actually working, should they receive the national minimum wage? That's already been heard by the Supreme Court, and we're waiting for the judgment. So I'm sorry it's a bit of a counter through all those areas, but they're all really important, I think, that employers need to be aware about at the minute. So I wanted to try and cover as much as possible. I'll now pass you over to Colin, who will talk a bit about his role, and then we'll go to Lucy for questions. I think we've got Colin.
Colin, you're on mute. We just need to unmute your microphone.
Oh, the saying.
Can't. Oh, hang on a minute. Bear with me one moment. Perhaps I can do it for you. Okay. It's not letting me do that. Well, listen, we'll have... I'm not quite sure why I can't unmute you there, Colin. Sorry about that. Hang on.
Right, we've done it now.
There we go. Okay.
Thank you. A few technical difficulties there.
No worries.
Thank you, everybody. My name's Colin Camber. I'm one of the business development managers employed at Citation. So just listening to Gillian talk, it's a huge area with some real serious implications. So again, I think always the advice is think about what you're doing, take advice, and always err on the side of caution, have good policies, have good procedures in place. This is where that sort of partnership comes into being. Citation, we can partner with our businesses, we can ensure that you are compliant, you've crossed the T's, you've dotted the I's, and that you have those documents in place for those problems and those curveballs that sometimes creep in when we least expect it. We're there to give you advice and guidance and support, and that's 24/7. That's not people talking from script. They're qualified, knowledgeable and experienced consultants directly employed by us to hold your hand and walk you through that potential minefield. We have forms and documents, checklists to help you ensure you're doing what you should be doing and reviewing. And then we have a very, very good, simple to use online system that just makes your lives as managers, employers a little bit easier to control, store and gather all that important information and signatures to say, yeah, I've had it, I've read it, I've understood. But I say there'll be an opportunity, if any of you'd like to take it up, to have a conversation with me at a point in the future. But I say thank you very much for your attendance today, and I'll hand you back over to Lucy.
Thanks, Colin. Thanks very much. Okay, so we'll try and whiz through some questions here, Gill. We've got quite a number of them, and don't know how many we'll have time for. I'm going to try and pick out some from each topic, so we've got a good balance. So the first one, going right back to the bear with me, hang on, last one there. Yeah, and going right back to the homeworking side of things is. I've not got the exact word in here, but the question was, how do you bring in people how do you return back into the office when you are allowed to return people back into the office, those employees who aren't shielding and aren't clinically vulnerable, but are just really, really frightened to return to work until they've been completely vaccinated? And I think the word completely vaccinated was to do with perhaps the second lot as well, which obviously there's a lapse in the two.
Yes, I think this was a huge issue for businesses last summer, and we had so many clients who had employees who were refusing to come back. I think the key thing is, first of all, to start talking in good time before you're expecting people to come back. It's never going to go well if you're saying on a Thursday, right, you're all back in on Monday. So start the conversation early. Make sure you're sharing what arrangements you've got in place to make sure the business is COVID secure, because, even if people are vaccinated, they are still going to be concerned. And the government has said, well, it's not 100%. So you've got to make sure that you're following the government guidelines on what is COVID secure, sharing that information with them. Again, where I've seen things go wrong in the past is that people have given short notice and just said, you don't need to worry, we've done everything we need to do, and not actually shared that information. And then when people are saying, I don't feel safe, see if there's a need for them to have an individual risk assessment, whether they have any particular vulnerabilities that from a health perspective that you don't know about. But really, you have to be very careful, because if people are saying, I do not feel safe in the work environment, that can lead to potential claims. And those claims are day one claims, and those claims are potentially unlimited, and there can also be whistleblowing issues there. So you need to be careful that you listen to exactly why they feel unsafe, doing everything you can to address those concerns. If someone is being unreasonable, there is no protection under the law for that. So that is the good news. But they will be judged not on what you know, but on what they know. So they need to know everything that you know when you've reached the assessment it is safe. And then, as I say, if they just don't refuse to budge, it may be that you would actually be able to take action against them. But there's quite a few steps to go in between there to make sure that you're doing it fairly.
Thank you. So going back to the testing element, there's actually 3 separate questions in here which are all kind of asking the same thing, which is around what's the position on testing for employers who have got less than 50 employees. So just because the government is saying that they're going to offer this to above 50 employees, is there a different stance on whether it's a reasonable thing to do? Is there any movement in the requirements to do it for those smaller businesses?
Well, you could undertake private testing, but again, for smaller business, that's likely to be quite expensive. I think, increasingly, when they did, for example, in the Prime Minister's speech, he was talking about smaller businesses having access to testing through community sites, but that's not the official scheme. If it were me, I would contact. I would actually probably try to register online or contact to see actually what guidance can be given. How can you get testing? So, for example, with day nurseries in that particular sector, I know that even though they may not have 50 employees, they're having tests available. So I would actually explore and see. I'm just trying to think because I actually did register to see what would happen. I don't think they ask you in the original registration questions, that online portal, how many employees you've got. So it may be worthwhile just trying to register, and then when they come back to you, exploring what support is available for you there. But definitely, I think the government wants to try and help wherever possible. So it's definitely worth exploring.
It sounds from here that there's quite a few businesses on this webinar, at least, that are keen to do that are really, really keen to implement it. On the vaccination area, I think we talked a lot about whether it was acceptable to ask somebody to be vaccinated, which of course it isn't, but can we ask to see whether people have been vaccinated? And if we can, would this include contractors and agency workers?
Oh, that's a great question. And it's, this is again going
Minefield.
to be such an absolute. I had, a client I was speaking to yesterday. They are a very large national contract cleaning business, and already they're having noises from their clients about whether or not, whether they would only accept people who are vaccinated onto their premises. So legally, again, there's no guidance on this, unfortunately, at all from the government. And of course, until it gets in front of tribunals, we're not likely to have any steer on what is definitively going to be reasonable. Legally, there's nothing wrong with asking an employee if they have been if they've been vaccinated at all. But it's a question of whether or not you can compel them to tell you, and that's the bit that we don't yet know whether it's going to be reasonable. Just as we don't know whether requiring them to have the vaccination is going to be reasonable. So the way I would just treat this is use the same principles you would in terms of actually imposing a compulsory vaccination policy. Think of it as, why do I need to know this? That's got to be your starting point. Why do I need to know this? Is there any other way I can achieve this? What am I going to do with that information? And, recognize that it has an impact on the individual. And then once you've done all that, if you're satisfied that on that balancing exercise, it's something you need to do, follow the same principles as you would do, as I was talking about in terms of imposing that policy. Speak to your employees, tell them why you need to know this, and that they are going to be required to tell you.
It's going to be a tricky area, isn't it? I think that's probably all we've got time for, which is a shame because we've had loads of different questions, but I think we were right to make sure that we covered as much as we could within those slides. So hopefully it's been a really valuable session for everybody who's attended. You will receive an email with the slides this afternoon, and there's an opportunity on that email to get in touch with us so that we can put you in touch with Colin if there's anything more that you need, if there's anything you didn't feel you get out of the session, or if it's raised a few concerns about how to manage things going forward. So thank you so much, Gill. It's always interesting listening to the back and forth of HR and employment law, and to Colin as well. Thank you very much. And thanks to everybody for joining. Okay.
Thanks. Bye, everyone.
Thank you. Bye.
Bye.